Hi, I'm Todd Street. I'm a lawyer working out of Thornton in New South Wales. Today I want to talk to you about preparing for your first meeting with a family lawyer with an emphasis on property settlement matters. So I'm working on the basis that you've got your first consultation organised and your appointment's coming up and you're wondering what you should take with you. When I do first consults, I focus on the 4 stages and try to get as much information about each of them as possible. That's identifying the asset pool, working out contributions, working out other needs, and then the just and equitable consideration. I'll talk about each of those in turn. Moving on to stage 1, identify the asset pool. So what are the assets, debts, superannuation of the relationship? What do you own? What does the other party own? And what do you own together? And also, there can be trusts and companies in a manner which are relevant to an asset pool, but their ownership structure can be a little bit different. So I'm interested in all of those things. The most common assets are things like houses, cars, boats, trailers, caravans, savings, shares, investments, household furniture, and the like. Debts are most commonly mortgages, personal loans, car loans, and credit card debts. And superannuation is more obvious. It's either in a complying fund, public complying fund, or it can be a self-managed superannuation fund as well. The next thing I'm interested in at this stage is what are the relevant assets, debts, and superannuation worth. Some of them are fairly easy to value, for example, superannuation, savings, but other things need some work done away from just looking at balances. For example, houses, you generally get appraisals or valuations, cars likewise. Then the more complicated matters, you can have companies that operate businesses, which can either have a value or not, depending upon the nature of the business and the assets of the business. Now, when I'm talking about stage 1, I'll say to a client, imagine putting everything that you own on the table in front of you and then taking a photo of it. Now, moving on to stage 2, contributions. It's really about who did what. And I'll explain what that means in a little bit more detail. There are a number of different types of contributions. One of those is initial contributions. So what did you have and what did your partner have when the relationship started? Often I see people who might have owned houses at the start of relationships. They might have had savings, motor vehicles, investments, those sorts of things. They can be relevant. So have a think about what you brought into the relationship, what the other party brought into the relationship, and as best as you can work out what the value of those things were when the two of you got together. So for example, you might have had a house which was worth $500,000 when you got together, which had a mortgage of $100,000, and it might be worth $750,000 now with a mortgage of $300,000. Those values are of interest to me when I'm talking to clients about stage 2. Contributions during the relationship. So who did what during the relationship? Who earned an income? Who made financial contributions? Was there any special sums that came into the relationship? For example, were there lotto wins, compensation payments? Did third parties from outside of the relationship give the parties or a party to the relationship sums of money? That sort of stuff. Non-financial contributions are about things like who looked after the house, the outside of the house. There might have been improvements done to a property, so there might have been an extension where one of the parties contributed their labour to the extension, so the parties didn't need to go and pay a subcontractor to do the work. Those kinds of things can be non-financial contributions. Finally, homemaker and parent, who looked after the house, if there are children in the relationship, who looked after the kids. Post-separation contributions. So it can be relevant in a few different ways. So somebody might have continued to pay the mortgage after the parties separated. Someone might have continued to look after the kids post-separation. Things like that. So just have a think about the contributions that were made during the relationship, what happened after the parties separated. So the way I explain stage 2 relative to stage 1 is who did what to get to the photo you took at stage 1. I explain it as though it's like a home video, looking back from the start of your relationship to the photo that you've taken. Who did what to get to where you are now. Stage 3, other needs. The classic consideration at this stage of future needs factors. There are a list of factors which commonly arise in the more garden variety sort of matter. So how much you and your ex-partner earn, any health issues for either or both of you, who's looking after the kids, whether there are other people that need to be looked after as well, for example, adult children with a disability or something like that. Financial resources, for example, does either party expect to receive an inheritance in the near future? And finally, waste, for example, if the asset pool or money you earned was wasted on gambling, drug use, those sorts of things, that can be of some relevance. Effective proposed orders on earning capacity. So, for example, if the property settlement would involve the selling of an investment or a business, then if one party's earning capacity is tied up with that, then that's obviously something which can be relevant too. Other orders, are you party to any previous orders, for example, orders for a superannuation split? I need to know about that. And finally, who's paying child support and what are they paying? Moving to the fourth stage, just and equitable, there are two main questions that arise under this stage. The first one is it just and equitable to make any orders? And the second one, is it just and equitable to make these orders? For a first consultation, I'm primarily interested in information about the first question. So, for example, there are some situations where parties will meticulously keep their finances separate, no kids, that sort of thing, and that is relevant at this stage. Some final thoughts. Firstly, the better prepared you are, the more you'll get out of the first meeting. Some people come to me and they don't know much about their matter at all. Other people come to me and they're able to tell me everything. Obviously, the more you're able to tell me about your matter, the more I'll be able to help you at a first consultation. If you don't know, or if there are gaps, that's fine, but just appreciate that will be a limitation on my ability to help you as much as I might be able to at a first consultation. Following on from that, the more you can tell your lawyer, the better their advice will be. Don't just focus on the best parts of your case. So, for example, I have some people come to me and they'll tell me all the good parts of their case, but they won't necessarily tell me some of the less strong parts of their case. And what that means is people might go away with a particular view about their case from a first meeting, but once we get into the nitty-gritty and I find out what the other party has to say, my advice can change. It's better for you if I have the breadth of information or as much as you're able to tell me available for a first consultation, because then I can really have a good talk to you about the strong parts of your case and perhaps parts of your case that you need to work on or you need to get some more information about. So what are you concerned about, and what would the other party say if given the opportunity to talk to me? Lastly, documents can be helpful in moderation. Coming here with some key documents that are focused on the things that I've talked about today are very good, but coming to me with bundles of documents is not going to be helpful in the same way. That concludes the presentation today. I hope it's been of help to you. Have a nice day. Bye now.